Have you ever found yourself scrolling through headlines, maybe, or just overheard a conversation and thought, wait, what does the law actually say about that?
Hmm.
Especially when it comes to something as serious and, frankly, as nuanced as weapons.
Right.
There's often this huge gap between, casual understanding and the precise legal definitions. And in a world just overflowing with information, cutting through that noise to get to the truth is, well, it's absolutely critical. Today, we're taking a deep dive into weapons offenses. We're specifically unpacking a key student handout from the Penal Code, Chapter 46.
Yeah, this is a foundational piece of text.
Exactly. Our mission for you, our listener, is to transform what could be a pretty dense, maybe intimidating legal document into clear, actionable knowledge. We want to give you a real shortcut to understanding these crucial elements, especially if you don't have a background in law. Think of this as your guide to becoming genuinely well-informed on a topic that, let's face it, truly matters.
And, to expand on that, this isn't just about memorizing rules. Our goal is really to connect the specific legal text to its real-world implications, helping you understand not just what the law says, but why those precise distinctions are so important. It's about empowering you with the kind of knowledge that fosters both informed citizenship and, frankly, personal safety.
Okay, so let's unpack this. Before we even get into what you can't do or where you can't go, we first need to understand the fundamental question. What is a weapon in the eyes of the law? Our source material, this handout, gives us incredibly specific definitions, and that's really where we have to start.
And what's truly insightful here is how meticulous these definitions are. They often include very specific examples or sometimes critical exclusions. This level of precision isn't just academic, it's vital for clear legal interpretation, making sure there's very little room for ambiguity in court. It stops broad assumptions and forces reliance on exact criteria.
Right, so let's begin with club. When you hear that word, you might picture, I don't know, any old stick, right? But the law has a much narrower definition.
Precisely. It's not just any stick you might find. The law defines a club as an instrument specially designed, made, or adapted for the purpose of inflicting serious bodily injury or death by striking. The key takeaway here is that the law isn't just about what looks like a weapon. It's about its intended purpose or how it's been adapted. The handout even lists specific examples to clarify. A blackjack, a nightstick, mace, and here they mean the blunt instrument, not the chemical spray,
Okay, good distinction.
and a tomahawk.
Yeah.
It's all about that specific, harmful purpose or design.
Gotcha. Next up, a chemical dispensing device. This one actually has an interesting and very practical exception built right into its definition.
It does. It's defined as a device for dispensing substances that cause an adverse psychological or physiological effect. Sounds pretty broad, right?
Yeah.
But it specifically excludes small chemical dispensers sold commercially for personal protection. So, in plain language, what this means is that common self-defense items like, say, pepper spray are generally not considered illegal chemical dispensing devices under this section. That exclusion is very intentional.
Okay, that makes sense. Now, here's where it gets really interesting and I think potentially quite confusing for people because we have three distinct categories that sound similar but are treated very differently. An explosive weapon, an improvised explosive device, or IED, and a hoax bomb.
Mm-hmm.
Why does the law bother with these separate definitions and why does that distinction matter so much?
It matters hugely because the intent, the components, and the actual threat level vary significantly for each one, and that leads to very different legal consequences. So an explosive weapon is the broadest category. It's basically any explosive or incendiary bomb, grenade, rocket, or mine that's designed, made, or adapted to cause serious bodily injury, death, or substantial property damage. It even includes things primarily designed just to cause undue public alarm or terror with a loud report. And this definition also covers any device made to deliver or shoot such a weapon. So, pretty comprehensive.
Right.
Now, an improvised explosive device, or IED, is much more specific. This is a completed and operational bomb, also designed for serious harm. But the crucial part is that it's fabricated in an improvised manner using non-military components. That distinguishes it from military-grade stuff. And here's another key point. The definition explicitly doesn't include unassembled components you can legally buy without special permits, nor does it cover those exploding targets sold in kit form for firearms practice, the ones with binary explosive components. So just having the pieces doesn't automatically make it an IED, and certain recreational items are carved out.
That's important. And the third one, the hoax bomb.
Right, the hoax bomb. This one is unique because it doesn't even have to be a functional explosive. It's a device that simply reasonably appears to be an explosive or incendiary device, or it's something that, by its design, causes alarm or reaction by an official of a public safety agency.
Yeah.
The key here is the perception of a threat, or the act of causing alarm, even if there's no actual boom capability.
Okay, that clarifies things a lot. Let's move on to firearms. What's the baseline definition for a firearm, and are there any, surprises in what's specifically excluded?
Well, generally, a firearm is any device designed, made, or adapted to expel a projectile through a barrel using energy from an explosion or burning substance, or anything that can be easily converted to do that. The interesting exclusions are antique or curio firearms manufactured before 1899 and replicas of those antiques. However, these replicas are only excluded if they don't use modern rimfire or centerfire ammunition. So really old historical pieces or non-firing replicas get treated differently. As for a handgun, that definition is pretty straightforward. It simply means any firearm designed, made, or adapted to be fired with one hand.
Simple enough. Our handout then lists some more specialized firearm types that have their own very specific definitions and rules attached.
Right. We have zip gun, which is essentially a device that wasn't originally a firearm but has been adapted, maybe crudely, to expel a projectile.
Yeah.
Then there's a machine gun, defined as any firearm capable of shooting more than 2 shots automatically without manual reloading by a single function of the trigger. That automatic multi-shot capability is the core feature.
Got it.
And finally, a short barrel firearm. This describes either a rifle with a barrel length under 16 inches or a shotgun with a barrel under 18 inches. Or it could be any weapon made from a shotgun or rifle that, once it's been altered, has an overall length less than 26 inches. These aren't just random numbers. They define weapons specifically regulated due to, well, their concealability and potential for harm.
Makes sense. We also have definitions for things like ammunition and even certain types of locations and personnel. These become really important when we talk about exceptions later on, right?
Absolutely. Just for completeness, the handout defines armor-piercing ammunition. That's handgun ammo designed mainly to penetrate metal or body armor. A tire deflation device is something like a caltrop or spike strip meant to puncture tires. Importantly, it doesn't include those legitimate traffic control devices that puncture tires in one direction, provided there's a clearly visible warning sign. The handout also defines volunteer emergency services personnel, like volunteer firefighters or EMS, but not peace officers, and a first responder, a public safety employee like fire or EMS, whose main job is rapid emergency response. Again, this excludes volunteers or peace officers. Understanding these distinctions for individuals is key because, as you said, they often pop up in the exemptions later.
Okay, so now that we have a solid grasp on what constitutes a weapon in legal terms, let's pivot to a really personal aspect of these laws. Who is restricted from having or carrying these items, and when those restrictions apply.
Right. This section outlines critical limitations based on someone's past actions or current legal status. These are some of the most common offenses people might encounter related to weapon possession.
Let's start with a big one that affects a lot of people. Convicted felons. What are the rules for someone with a felony conviction when it comes to possessing a firearm?
For someone convicted of a felony, the rules are quite strict and very time-sensitive. Before the 5th anniversary of their release from confinement or supervision or parole, whichever is latest, they cannot possess a firearm at all, period.
Okay, 5 years? Nothing.
Right. After that 5-year period has passed, they're only permitted to possess a firearm at their residence, nowhere else. And for this section, a felony is defined pretty broadly. An offense designated as a felony by the state, one that contains all the elements of a state felony, or just one punishable by 1 year or more confinement in a penitentiary.
Are there other categories of people besides felons who are prohibited from possessing firearms under certain circumstances?
Yes. The handout details several others. For example, members of a criminal street gang commit an offense if they intentionally, knowingly, or recklessly carry a handgun, specifically in a motor vehicle or watercraft. Also, individuals convicted of a certain type of family violence Class A assault are prohibited from possessing a firearm before the 5th anniversary of their release from confinement or supervision. And a critical one, if you are the subject of an active protective order, like a restraining order, and you've officially received notice of that order, you are prohibited from possessing a firearm before the order expires. There is an exception here, though, if you happen to be a sworn, full-time paid peace officer actively engaged in your employment duties.
Okay. And what are the consequences for violating these unlawful possession rules? What kind of trouble are we talking about?
For felons who violate these possession rules, it's a significant charge, a felony of the third degree. For the others we mentioned, criminal street gang members, those family violence convicts, and people under protective orders, it's generally a Class A misdemeanor. You start to see a pattern. The more serious the underlying reason for prohibition, generally the higher the penalty.
Right. So beyond just possessing a weapon, there are also very specific rules about carrying them, which is different. What's the general rule for carrying handguns specifically?
Yeah, carrying is distinct. The general offense for unlawfully carrying a handgun applies if the person is younger than 21 years of age, or if they've been convicted of certain specific offenses, things like Class A assault, deadly conduct, terroristic threat, within the preceding 5-year period. But this is where the exceptions are really critical. These rules generally don't apply if the person is on their own premises or premises under their control.
Like their home or business?
Exactly. Or if they are inside of or directly en route to a motor vehicle or watercraft that is owned by the person or under the person's control. So your own property and your own vehicle are key exceptions here.
What about carrying a handgun in a vehicle or, displaying it publicly? That seems like a common area where people get confused.
It really is. So carrying a handgun in a motor vehicle or watercraft that you own or control can be an offense if the handgun is in plain view.
Okay.
Unless, and this is important, you are 21 or older, or you are licensed to carry a handgun, LTC holder, and the handgun is carried in a holster.
So the holster makes a difference for plain view in a car if you're licensed or over 21.
Correct. It's also an offense to carry in the vehicle if you're simultaneously engaged in criminal activity, though minor Class C traffic or boating offenses don't count for this.
Yeah.
Or if you're already prohibited by law from possessing a firearm for some other reason, like being a felon.
Mm-hmm.
As for displaying it in public, it's an offense if you intentionally display the handgun in plain view of another person in a public place.
Yeah.
But again, the crucial exception, it's okay if it was partially or wholly visible but was carried in a holster. So holstered carry, even if somewhat visible, generally gets treated differently than just having it out in the open.
And what if someone is intoxicated while carrying a handgun? Is that allowed?
Generally, no. Carrying a handgun while intoxicated is an offense. Unless, again, those location exceptions apply. They are on their own property or property under their control, or on private property with the owner's consent. Or, similarly, if they are inside of or directly en route to a motor vehicle or watercraft that they own or control or have consent to be in. The core idea is that intoxication and carrying don't mix in public, but the rules relax a bit on your own turf or in your own transport.
Okay. And what about knives? There's a special category here beyond just, any kitchen knife.
Yes, the law specifically defines a location-restricted knife, or LRK. That's a knife with a blade over 5 1/2 inches.
Over 5.5 inches. Got it.
Right. This is distinct from the general definition of a knife, which is just any bladed hand instrument capable of inflicting serious bodily injury or death. Carrying an LRK, one of those longer knives, is generally an offense if the person is younger than 18 years of age. But similar to handguns, it's not an offense if they're on their own premises or premises under their control, or inside of or directly en route to a motor vehicle or watercraft they own or control. And crucially for minors, it's also okay if they are under the direct supervision of a parent or legal guardian.
Okay, so supervision matters for minors with those knives. What are the general penalties for these unlawful carrying offenses we just discussed?
For most of these unlawful carrying offenses, like carrying without meeting age or conviction requirements, or the plain view violations, they're typically classified as Class A misdemeanors.
Mm-hmm.
However, and this is a big jump, carrying a handgun when you are already prohibited from possessing a firearm under Section 46.04, like if you're a felon, results in significantly higher penalties. That bumps it up to a felony of the second or third degree, depending on the specific prohibition.
Wow, okay.
And for minors unlawfully carrying a location-restricted knife, it's usually a Class C misdemeanor, which is the lowest level misdemeanor, basically like a traffic ticket.
Mm-hmm.
So the law really scales the punishment based on the perceived danger and the individual's legal status.
Right. Okay, here's where we get into the places where weapons are generally not allowed. This can be confusing, I think, because there are specific types of locations and often these nuanced exceptions you need to be aware of.
Absolutely.
Even if you can legally possess a weapon, where you carry it is critical.
This section is absolutely crucial because even if you can legally possess or carry a weapon under the rules we just talked about, certain locations have absolute or at least highly restricted prohibitions. Knowing these boundaries is fundamental to avoiding potentially serious legal trouble.
Before we dive into the actual list of prohibited places, Let's clarify some terms the law uses for these locations. Their definitions can be very precise, right?
Incredibly precise. So the handout defines institution of higher education and post-secondary educational institution, basically schools beyond high school, like colleges and universities. Now, this is really important. Premises for this section means a building or a portion of a building. But listen to this. It specifically does not include any public or private driveway, street, sidewalk, walkway, parking lot, parking garage, or other parking area.
Wait, so the parking lot of a prohibited building might not be prohibited itself?
Exactly. That seemingly small detail about premises excluding parking lots is a critical, often misunderstood nuance. You could potentially legally possess a weapon in a parking lot right next to a building where it's prohibited inside. It really highlights how precise and sometimes maybe counterintuitive these legal boundaries can be. You have to pay attention to the specifics.
Definitely. Okay, what else?
A school means an accredited primary or secondary school, K through 12. And a secured area of an airport refers to areas where access is controlled by TSA or federal inspection, or specific aircraft parking areas used by airlines. Crucially, it does not include baggage claim, public parking, or the drop-off pickup areas outside.
Okay, good to know. So, armed with those very specific definitions, where can you not intentionally, knowingly, or recklessly possess or go with a firearm, location-restricted knife, club, or other prohibited weapon? What's the list?
It's quite a list.
Mm-hmm.
First, on the premises of a school or post-secondary educational institution. That includes any grounds or building owned by and under the control of the school where a school-sponsored activity is happening, or even in their passenger transportation vehicles, like a school bus.
So, K-12 schools, colleges, universities, pretty much off limits generally.
Generally, yes. But there's a major exception specifically for post-secondary institutions, colleges, and universities. A person with a license to carry a handgun, an LTC holder, can carry a concealed handgun on these premises. Unless the institution has established specific written regulations prohibiting it, or they've posted effective notice, like those specific signs we'll talk about. However, even for LTC holders, it is always an offense to intentionally display a handgun in plain view on any higher education premises, including its driveways, streets, sidewalks, parking lots, etc., regardless of whether it's holstered or not.
So concealed carry might be allowed for LTC holders on campus, but open display is basically a no-go everywhere on campus property.
That's the gist of it, yes. Concealed is the default expectation for LTC holders there, unless rules say otherwise.
Okay. What other places?
A polling place, on Election Day or during early voting, the premises of any government court or offices utilized by the court, unless you're specifically authorized by the court, and the premises of a racetrack.
Mm-hmm.
You also cannot possess these weapons in or into a secured area of an airport.
Right, the area past security screening.
Exactly. But remember that crucial defense we touched on. If you have a licensed handgun and you accidentally bring it to a screening checkpoint, it's a defense if you immediately exit the secured area after they notify you. Peace officers are actually required to tell you about this defense and give you a chance to leave.
That's a really important practical point. Okay, keep going down the list. All right.
Within 1,000 feet of a TDCJ execution site, that's the Texas Department of Criminal Justice, on the day an execution is scheduled, if you've received notice. There's an exception if you're just driving past on a public road or if you're at your own home or job within that zone. Next, on the premises of a business that derives 51% or more of its income from the sale or service of alcoholic beverages for on-premises consumption, these are often called 51% bars.
Right.
Now, for LTC holders, this prohibition doesn't automatically apply unless the business has given them effective notice of the prohibition, usually through specific signage, like a 30.06 or a 30.07 sign.
Okay, so notice is key for LTC holders in bars. What else?
You also can't possess these weapons on the premises where a high school, collegiate, or professional sporting event or interscholastic event is taking place, unless you're actually a participant and the weapon is used in the event, like maybe target shooting. For collegiate sporting events specifically, LTC holders are generally exempt unless, again, they're given effective notice that weapons are prohibited.
Seeing a pattern with LTC holders and notice.
Definitely. The list continues with correctional facilities and civil commitment facilities. Also, licensed hospitals or nursing facilities and mental hospitals, unless you have written authorization. Though, again, for LTC holders, the prohibition at regular hospitals doesn't apply unless they've been given effective notice.
Okay, almost there.
Almost. Possession is prohibited in an amusement park. Now, amusement park is a specific definition. Large, permanent facility, controlled access, security, open more than 120 days a year. Think major theme parks. And, you guessed it, LTC holders are generally exempt unless given effective notice. And finally, in the room or rooms where a meeting of a governmental entity is held, if it's an open meeting subject to the Open Meetings Act and proper notice about the weapon prohibition was provided.
Yeah.
So you generally can't take your weapon into, say, a city council meeting if they've posted the proper notice.
Wow. That is a lot to remember with all those specific places and the various exceptions, especially for LTC holders depending on notice. What are the general penalties for violating these places prohibited rules?
Most violations of this section carrying in these prohibited places are considered a felony of the third degree, so pretty serious. However, if the weapon involved is just a location-restricted knife, that blade over 5.5 inches, it's typically only a Class C misdemeanor. The exception is if you carry that LRK into a school, then it jumps up to a felony of the third degree.
Also, several of the specific offenses we listed, like carrying at sporting events, hospitals, amusement parks, and those higher education display violations are actually classified as Class A misdemeanors, not felonies. So, while many are felonies, there's definitely a scaling of punishment based on the specific location and sometimes the weapon type.
It really sounds like there's a big emphasis on notice in many of these situations, especially for licensed carry. So what if someone genuinely just didn't know a place was prohibited, maybe missed a sign or something, and then gets told? Is there any kind of general defense for that honest mistake?
Yes, there is. There's a very important prompt departure defense that can apply in some situations. It's a defense to prosecution if you meet three conditions. 1, you carried a handgun onto prohibited premises. 2, you personally received notice from the owner or someone with apparent authority that carrying was prohibited. And 3, you promptly departed from the premises after getting that notice. It's basically designed to give people a chance to comply once they're made aware, rather than immediately facing charges for an accidental violation.
That seems fair. But does that defense always work?
No, not always. This defense specifically doesn't apply if a certain type of sign, which the code describes in detail, was prominently posted at each entrance, giving notice that weapons are prohibited. Or it also doesn't apply if, at the time you entered, you already knew that carrying a firearm or weapon on that property was prohibited. The law kind of assumes you should pay attention to posted signs or already know the rules for certain places.
So what exactly does that specific sign you mentioned look like? Does it have to be a certain size or say certain words to be considered effective notice that blocks that defense?
It does. The requirements are quite specific to ensure it provides clear warning. The sign must include language identical or substantially similar to. Pursuant to Section 46.03 Penal Code, places weapons prohibited, a person may not carry a firearm or other weapon on this property. That exact language, or something very close to it. It has to be in both English and Spanish. It must appear in contrasting colors with block letters at least 1 inch high. And it needs to be displayed conspicuously and clearly visible to the public at each entrance to the property. So it's quite prescriptive. When you hear the term effective notice in these regulations, often involving signs like 30.06 or 30.07 for LTC holders, or this general 46.03 sign, they usually mean signs meeting these kinds of detailed requirements.
Right. Got it. We've covered an incredible amount of ground so far. The what of weapons, the who can possess or carry, the where they're prohibited. But the law also addresses other related conduct, like how weapons are transferred and, importantly, who might be exempt from some of these rules entirely.
Exactly. Understanding these additional offenses and, maybe just as importantly, the extensive list of exemptions is key to getting the full comprehensive picture of these weapon laws. It's all part of this intricate web of regulations.
Okay, let's look at this next section, prohibited weapons. This sounds like it's about items that are generally just illegal to even possess, manufacture, or sell, regardless of location or who you are, unless there's a very specific exception. What falls into this category?
Right. This section lists several items that are broadly prohibited, unless they fall under very specific federal regulations, like being registered in the National Firearms Registration and Transfer Record, or if they're classified as curios or relics. The main ones listed here are explosive weapons, machine guns, or short-barrel firearms. Possession of these, unless you meet those narrow exceptions, is generally illegal. It also prohibits possessing armor-piercing ammunition, chemical dispensing devices, remember the exception for personal protection spray we talked about earlier doesn't apply here necessarily, zip guns, tire deflation devices, and improvised explosive devices. Generally, possessing, manufacturing, transporting, repairing, or selling these items is a felony of the third degree, though possessing a tire deflation device is a state jail felony, or SJF, which is a slightly lower level felony category in Texas. There are defenses, of course, like performing official duties or if the item is an antique or curio handled according to federal law. And there's a specific defense mentioned for security officers who have received training and are carrying a chemical dispensing device while on duty.
Okay. This next one is very specific, too, and sounds quite serious. Unlawful possession of metal or body armor by a felon.
Indeed. Metal or body armor is defined basically as anybody covering clearly designed to protect a person against gunfire. The offense applies if a person who has been convicted of a felony possesses this kind of armor after that conviction. It's a felony of the third degree. The idea behind it, presumably, is to prevent individuals with a serious criminal history from possessing protection that could potentially aid them in committing further violent crimes.
Makes sense. Now, this next section shifts focus from possessing to giving or selling weapons. Unlawful transfer of certain weapons. This also comes with its own set of strict rules, doesn't it?
Absolutely. Transferring weapons improperly carries significant legal weight. There are several key restrictions here. First, it's an offense to transfer a handgun if you know the person receiving it intends to use it unlawfully. That seems straightforward. It's also generally prohibited to intentionally or knowingly sell, rent, lease, or give any firearm, club, or location-restricted knife to a child younger than 18. This actually becomes a state jail felony if the item transferred is a handgun.
Okay, so giving a handgun to a minor is a felony, generally.
Generally, yes. However, there's a critical affirmative defense here. It's okay if the child's parent or legal guardian gave written permission beforehand or gave what the law calls effective consent. So a parent could, for instance, give their underage child permission to possess or use a firearm under supervision.
Right. What other transfer restrictions?
It's an offense to sell a firearm or ammunition to someone you know is intoxicated. Also, to knowingly sell a firearm or ammunition to a convicted felon before their 5th anniversary of release from confinement or supervision. You also cannot transfer a handgun to someone if you know they have an active protective order entered against them. And conversely, you can't knowingly purchase or receive a handgun as a loan or gift if you are the subject of an active protective order. Finally, it's an offense if you are already prohibited by federal law from possessing a firearm, like being a felon, and you knowingly make a material false statement on a required firearm transfer form when trying to buy from a licensed dealer, lying on the form.
And the penalties for these transfer violations?
They're generally a Class A misdemeanor. But transferring a handgun to a minor or making that false statement on the firearm form while prohibited, those are both state jail felonies.
Okay. Briefly, what about hoax bombs and components of explosives? These sound related to the definitions we covered earlier.
They are. For hoax bombs, it's an offense to knowingly manufacture, sell, purchase, transport, or possess one with the intent to make someone else believe it's a real explosive or incendiary device, or with the intent to cause alarm or reaction from a public safety agency. That's Class A misdemeanor. Components of explosives is about possessing components of an explosive weapon, like the raw materials, with the specific intent to combine them into a weapon for a criminal endeavor. That's a felony of the third degree. So even just having the parts with criminal intent is a serious offense.
Got it. This next one isn't a new crime itself, but an enhancement to existing ones. The weapon-free school zone penalty enhancement. What does that mean for someone who commits a weapons offense near a school?
This is a really important enhancer. It means that if someone commits an offense under this chapter, Chapter 46, Weapons Offenses, within 300 feet of the premises of a school that's private or public elementary or secondary schools, or if they commit the offense on premises where an official school function or a UIL, University Interscholastic League, event is taking place, and the person knew it was such a place, then the punishment for the original offense is increased to the punishment prescribed for the next highest category of offense. So, for example, if the original offense was a Class A misdemeanor, committing it within that school zone bumps it up to a state jail felony. If it was an SJF, it becomes a third-degree felony, and so on, up the ladder.
Wow, so a significant increase in penalty just for being near a school.
Exactly. It's designed to create a stronger deterrent around schools. It's important to note, though, this enhancement doesn't apply to the initial offenses we talked about under 46.03a that already specifically prohibit weapons directly on school premises, because those already carry severe penalties. This enhancement applies to other Chapter 46 offenses that happen to occur near a school.
Okay, that makes sense. Now, making a firearm accessible to a child, this seems like a critically important law for any firearm owner really aimed at preventing tragic accidents.
It absolutely is. The core offense here occurs when, with criminal negligence, which is a specific legal standard, meaning the person should have been aware of a substantial and unjustifiable risk. A child younger than 17 gains access to a readily dischargeable firearm. Readily dischargeable basically means loaded with ammunition, even if a round isn't actually in the chamber.
Okay. And how does the access happen?
It happens because the person either failed to secure the firearm or they left the firearm in a place to which the person knew or should have known the child would gain access. And secure in this context means taking reasonable steps to prevent a child's access, including things like putting it in a locked container using a trigger lock or storing it in a gun safe.
What are the penalties?
It's typically a Class C misdemeanor, so a relatively minor offense. However, it becomes a much more serious Class A misdemeanor if the child actually discharges the firearm and causes death or serious bodily injury to themselves or someone else. There are some affirmative defenses, though. It's a defense if the child's access was supervised by an adult for lawful purposes like hunting or target practice, or if the child used it in lawful self-defense or gained access by trespassing illegally, or if it happened as part of a legitimate agricultural enterprise. And another point here. Firearms dealers are legally required to post a specific warning sign in their premises in block letters at least 1 inch high, stating, "It is unlawful to store, transport, or abandon an unsecured firearm in a place where children are likely to be and can obtain access to the firearm."
That's a very direct warning. Okay, finally, on the criminal side of things, what about firearms smuggling?
Firearms smuggling involves knowingly engaging in the business of transporting or transferring a firearm that you know was acquired illegally or is intended to be used in violation of federal or state law. The term business here is key. It's defined as conduct that occurs on more than one occasion or is done for profit or any other form of remuneration. So it's aimed at people involved in the ongoing illegal trafficking of firearms, not just a single isolated incident. The penalties are a felony of the 3rd degree, but that escalates to a felony of the 2nd degree if the offense involved 3 or more firearms smuggled during a single criminal episode. Peace officers performing official duties are exempt.
Okay, so we've walked through a lot of prohibitions and offenses. Now, for maybe the final piece of this complex puzzle, who are the people or what are the situations where these laws we've been discussing generally don't apply? This seems critical for understanding the full scope.
It really is. This section, 46.15, lists non-applicability or exemptions. It's a lengthy but incredibly important list because it clarifies who has specific legal authority or exemptions from many of the weapons offenses we've covered. For clarity, maybe we can group them into a few key categories.
Yeah, that would help.
Okay, first, a large category is law enforcement and public safety officials. These individuals are broadly exempt from many restrictions. This includes active peace officers and special investigators listed under the Code of Criminal Procedure. They could basically carry weapons pretty much anywhere in the state, even in public establishments, regardless of whether they're on or off duty. It also includes parole officers and community supervision officers when they're engaged in their official duties and following their department's policies regarding firearms. Active or honorably retired judicial officers, like judges, are exempt if they hold a license to carry a handgun, LTC. Same for honorably retired peace officers who maintain proficiency and carry the proper ID. Certain attorneys, the Attorney General, U.S. attorneys, district attorneys, county attorneys, and their assistants are also exempt if they hold an LTC. Bailiffs are exempt if they have an LTC and are escorting a judicial officer. Juvenile probation officers authorized to carry are exempt. And volunteer emergency services personnel, like volunteer firefighter CMS, are exempt from certain carrying restrictions if they hold an LTC and are providing emergency services. Lastly, in this group, first responders, paid fire EMS, etc., are exempt from unlawful carrying if they're carrying a handgun concealed or in holster, have a required certificate of completion, are on duty, and employed supervised by a municipality or county. So a very broad group of officials.
Okay, that covers a lot of public safety roles. What's next?
Next category, security professionals. They also have specific exemptions. This includes commissioned security officers regulated by the Occupations Code if they are engaged in their duties or traveling directly to or from an assignment, and they're either wearing a distinctive uniform with the weapon in plain view or carrying it concealed if out of uniform. Personal protection officers, bodyguards, are also exempt under similar conditions, carrying their commission and authorization and either wearing a uniform with the weapon open or carrying concealed without a uniform while performing their duties.
All right. Law enforcement, security. What else?
Then we have exemptions for special circumstances and activities. This is kind of a catch-all for various situations. There's a general exemption for traveling. This is a somewhat broad term interpreted by courts, but generally covers journeys beyond one's routine. There's an exemption for engaging in lawful hunting, fishing, or other sporting activity on the premises where it's conducted, or while directly en route if the weapon is commonly used in that activity. So carrying a hunting rifle while going hunting is obviously okay. Participating in historical reenactments according to specific alcoholic beverage code rules is exempt. Carrying a handgun during a declared disaster evacuation or a reentry period is also exempt for up to 7 days, 168 hours, or longer if the governor extends it, provided the person isn't otherwise prohibited by law from possessing a firearm.
That's interesting, a specific disaster rule.
Yeah. And relatedly, carrying handguns can be allowed in emergency shelters during a declared disaster, but only if authorized by the shelter's owner or operator and according to their rules. And we already mentioned those specific airport defenses for LTC holders at screening checkpoints who immediately exit upon notification. That falls into this section too.
Okay. Any other notable exemptions?
Just a few more specific ones. People who hold an alcoholic beverage permit or license, or their employees, are exempt from unlawful carrying if they're supervising the operation of the licensed premises. Law enforcement students enrolled in a training course are exempt from unlawful carrying during required class activities if the weapon is commonly used in the activity and it's carried unloaded when they're traveling to or from the class. And finally, animal control officers or state, local, federal code enforcement officers are exempt from the prohibition on carrying a club specifically if they're certified and carrying it solely for protection against animal bites while performing official duties or traveling to from duty. So as you can see, this incredibly long list really underscores how many specific carve-outs and situation-dependent rules exist within these seemingly broad weapon laws. It's not simple.
No, it definitely isn't simple. So what does all this really mean for you, the listener? We've covered an incredible amount of ground today, haven't we? From the very specific definitions of what legally constitutes a weapon.
The clubs, the knives, the different types of firearms and explosives.
Right, to who can and cannot legally possess or carry them based on age, criminal history, or other factors.
Yeah, the rules for felons, minors, people under protective orders.
And that where those numerous places where weapons are generally prohibited, like schools, bars, airports, government buildings, with all those exceptions we talked about.
And the critical role of notice and signage in many of those locations.
Exactly. Plus the how of things like transfers, making firearms accessible to children, and that whole complex web of exemptions for different people and situations.
We've really seen today that the law in this area is incredibly detailed and maybe above all context dependent. What might seem like a simple question, can I have this here, often has very nuanced answers rooted in those precise legal definitions and those very specific exceptions. These laws are clearly designed with very particular scenarios and concerns in mind, which is precisely why a deep dive into the actual text, like we did today, understanding these distinctions, is so valuable. It's not just about knowing a rule, but knowing the right rule for the specific circumstance.
Absolutely. Our goal today was really to give you a shortcut, a way to become truly well-informed on this complex topic, cutting through some of that dense legal jargon and getting to the most important nuggets of knowledge. We sincerely hope this deep dive has provided you with clarity and a much better understanding of these critical regulations, especially if, you don't spend your days reading the Penal Code.
And, thinking about all this complexity raises a really important question as we wrap up. Given just how intricate these laws are, how might public understanding and compliance actually be improved beyond just, handing someone a copy of Chapter 46? What role could clearer communication, maybe more accessible explanations like we aim for today, play in fostering genuinely responsible behavior in this highly regulated and frankly high-stakes area? Something to think about.
That is a powerful thought to end on. Thank you for diving deep with us today. Keep seeking out knowledge, keep asking questions, and we'll be here to help you unpack it.